Ladies and gentlemen, I instruct you that Code Section 44-53-110 provides certain definitions. Controlled substance means a drug, substance, or immediate precursor in Schedules 1 through 5. Distribute is defined as meaning to deliver other than by administering or dispensing a controlled substance. I further instruct you, ladies and gentlemen of the jury, that any crime is a combination of act and evil intent. General intent may be inferred from the act itself if the jury factually so finds, but this inference may be removed by attendant circumstances and evidence. Specific intent requires a finding that a state of mind to violate the law existed in the mind of the defendant. This must be proven by actual evidence and not mere inference. I further charge you, possession with intent to distribute marijuana requires a finding by the jury based upon evidence that a specific intent to distribute so existed. And under Schedule 1D, marijuana is a controlled substance under the drug laws of this state. And I further charge you that Code Section 44-53-110 provides subsection A as follows. It shall be unlawful for any person to possess with intent to manufacture, distribute, or dispense a controlled substance. It is further the law of this state that it is a violation of law to possess marijuana of more than an ounce or to possess marijuana of less than an ounce. It is further provided in Section 44-53-370, D subsection 3 as follows. Possession of more than 28 grams or 1 ounce of marijuana shall be prima facie guilty of violation of subsection A, which is the prohibition against possession with intent to distribute. Prima facie case is such as will suffice until overcome by other evidence. A prima facie case is made out against the defendant if there is sufficient proof to find him guilty, if he does not submit any evidence. In other words, the statute provides that possession of more than 28 grams or 1 ounce of marijuana creates a legal presumption that the illegal drug was possessed with the intent to distribute or sell it. This presumption, however, is rebuttable by the evidence. The standard by which a defendant may rebut any legal presumption that may have arisen is by the preponderance or greater weight of the truth. The weight of evidence depends upon its convincing character. An accused has possession of contraband material within the meaning of the law when he has both the power and intent to control its disposition or use. I further instruct you that proof of possession of a controlled substance requires more than proof of mere presence, and the state must show the defendants had dominion, control, over the thing allegedly possessed, or had the right to exercise dominion and control over it. Possession of an article may be inferred from circumstances. I further instruct you, ladies and gentlemen of the jury, that while actual knowledge of the presence of marijuana is such strong evidence of the intent to control disposition or use that knowledge can often be equated with and substituted for the intent element. Actual knowledge of physical presence is not the only circumstance from which the intent to control the disposition or use of an illegal substance can be inferred. An accused has such possession as is necessary for conviction of possession of marijuana when he has both the power, actual or constructive control, and intent to control its disposition or use. Constructive possession or control may occur when the accused has dominion and control over either the drugs or the premises upon which the drugs or controlled substance may be found. Possession means more than simply having it on your possession or in your possession. We have to add to that word knowing possession. There must be known possession of the drug by the alleged defendant. The further fact the alleged defendant knew that he had it in his possession, on his person, or about his person, or under his dominion and control.